Okay, class, in this area we're going to talk about the nature and sources of law. There is a distinction in classifying the law. You can distinguish between whether it's criminal versus civil. And criminal law deals with crimes which are considered to be offenses against the state or society as a whole. It also can be an offense against the federal government. For criminal laws, there are different penalties. You could have someone going to jail, paying a fine, or even death. Um, for criminal law, the standard of proof is beyond a reasonable doubt. And that means that there cannot be any reasonable doubt. If there is reasonable doubt, then you have to acquit or find the defendant not guilty. With civil law, the crime is against a particular individual. For example, if you are in a car accident and someone hits you, you would sue that person or their insurance. That would be against a particular individual. Whereas with a crime, murder would be against society as a whole. For civil law, there can be the penalty or punishment would be monetary, or it could be equitable remedies or equitable damages. The standard of proof is more likely than not, which means 51% for more likely than not that somebody is liable or responsible for the particular action. With every law, there is a right and there's also a coexisting, duty. So a right is a benefit. It allows a person the ability to require another person to produce something or refrain from doing something. So I have a Fourth Amendment right to be protected against unreasonable search and seizure by the government. That is a right that citizens have. The government would have a duty to uphold that right. The government could include the state, it could be the federal government, but a duty is an obligation that's imposed upon a person or a particular entity to either perform something or to keep from doing something. So with each law, there is a right and also a duty. The sources of law, where does law come from? Law comes from all the statutory law is one source of law. This could be federal or also could be state level. And statutory law is law that is enacted by either Congress on the federal level or the state legislature. So a federal law or act, it's the same thing, would be the Family Education Rights or the Privacy Act and Privacy Act, or what's considered to be FERPA, or the Buckley Act, which is also another name for it. But FERPA, you're very familiar with. FERPA is actually says that students have a right to privacy with their records. So if you have not waived your FERPA rights, I cannot talk to your parents about your grades. So that's a federal act or statute that was enacted by Congress. A state example would be the North Carolina General Statutes, Section 4242, which deals with landlord-tenant law. And this actually, for example, allows for landlords to have certain rights and also tenants to have certain rights. There are also uniform laws, which are laws that states have adopted so that transactions between the states would be uniform. An example is the Uniform Commercial Code, which is an appendix in your book. The Uniform Commercial Code basically holds or regulates different areas. For example, it regulates the sale of goods, which is Article 2 of the Uniform Commercial Code. There are also constitutional rights. The constitutional rights can come from the federal constitution, U.S. Constitution, and also the state constitution, because the states have constitutions. You can have more rights provided by the states, but not less. An example of a constitutional right would be the 14th Amendment, 5th Amendment due process rights. Due process deals with the ability to have a hearing or some type of hearing before your life, liberty, or property is taken. It also deals with certain privacy rights that have been inferred by the actual Supreme Court hearings, which we'll talk about in class. But constitutional rights is another source of law that you have. You also can get law from court decisions, which can come from your Supreme Court or also your courts on the federal court system or the state courts. And when court decisions are made, they will set precedent, which will be laws that will be followed by the same court on similar or same issues. Just because precedent or court decisions become precedent does not mean that the court will not overrule the decision under certain circumstances. Now, the idea of let the decision stand establishes, is the Latin phrase, that court decisions become precedent to be followed in future court decisions on the same or similar issues. That means that your court decisions become laws. They can obviously be changed or reversed, but that idea of stare decisis establishes let the decision stand. Obviously, there's some exceptions to this doctrine. There's also constitutional rights, which I've talked about. We'll talk about equal protection, but an example of a court decision that we are going to look at and talk about is Plessy v. Ferguson, which dealt with equal protection rights. And in Plessy v. Ferguson, the court held that separate but equal or Jim Crow laws was constitutional. We'll look and talk about the facts of those cases, that case a little bit more, and the cases together with Plessy and also Brown. But the holding was that separate but equal is constitutional and does not violate the 14th Amendment equal protection law. However, that decision was overruled by Brown v. Board of Education, which held that separate but equal is unconstitutional, and separate but equal laws do violate the 14th Amendment equal protection clause. Some of the arguments that we'll look at or that came up in Plessy is that Plessy was white and deserves to sit with the white passengers, because Plessy was 1/8 African American, and so it was considered to be African American. But the argument was that he was Caucasian and should have been able to sit in the Caucasian train or car, because it was divided up into, and this is in quotes, colored versus whites or Caucasians. The second argument is not the law's responsibility to make distinctions between the races from a social context. That was the argument that Plessy's attorney made. Segregation laws are under the state's police powers as long as they're reasonable. The 13th Amendment does not apply because this case does not involve servitude. So this was the argument that the other side actually made. And then, so this is a combination of the arguments here. And then 5, separate but equal is valid as long as the facilities are equal. So these distinctions are what the focus here was. What the court actually looked at was that separate but equal is valid as long as the facilities are equal. But these are the arguments that were made, and mainly, actually, I will say these arguments were made, at least looking at the 2 through 5, by the winning side in that case. Sources of law can also come from common law, which is our Old English law. And common law has been replaced in many cases by statutory law. But the common law definition of murder is the unlawful killing of a human being with malice. Notice that it had to be a human being, and we'll talk about that. And then burglary, the breaking and entering of a dwelling house of another in the nighttime with the intent to commit a felony. Notice that for burglary, under the common law definition, you had to have a dwelling house, and also you had to have at nighttime. So that's problematic. Law can also be classified based on the subject whether it's contract law, employment law, constitutional law, administrative law, or agency law. We'll look at both of or all of these types of laws in this class. And then substantive versus procedural. Substantive law defines the rights and liabilities. So, for example, how negligence, which is a legal claim that can be brought, is defined. Negligence is when someone has a duty of care, they breach that duty, and because of that, it actually causes some type of harm. So the actual definition is substantive. Procedural law is the procedures that have to be followed to enforce the law. And then if you're talking about monetary damages, this at equity. If you're talking about when money's not enough, monetary damages is at law. So anytime it's monetary damages, that's at law. If you're talking about equitable damages, that would be when money's not enough. So let's make sure at law is monetary damages and equitable remedies are when money's not enough. For example, specific performance would be an example of an equitable remedy. Specific performance is when someone breaches a contract, the court orders the person who breaches the contract to perform the contract. So we'll talk about that a little bit more also in this area. Let's look at a couple of examples of classifying substantive versus procedural. Laws that require public schools to hold a hearing before a student is expelled. That would be the procedure, how you would expel a student. A law that provides employees leave for the birth, adoption of a child up to 12 weeks. That's the Family Medical Leave Act. That defines the law. The procedure in enforcing the law would be procedural, but this is actually substantive. And a law that requires the county assessor to send 4 notices of taxes due before a lien can be filed on the property. That is actually an example of procedural law, the process in enforcing the law.